could handle his finances for him. Well, his wife and his daughter opposed that document and said to the court, we are his wife and daughter, and if anybody should be making financial decisions for him, it should be us. And the court disagreed. The court said that under the Massachusetts Durable Power of Attorney law, the business partners trump the wife and the daughter and can make the decisions, because in Massachusetts, if you have a validly executed durable power of attorney, then the person nominated to serve as the agent under that document shall serve unless, for due cause or some extraordinary reason, the person is proven to not be able to serve as guardian or decision maker.
Wow. Well, what other type of documents should people consider in our community? That's obviously very important.
Yes, the other document that is so important, and we just forget about them in the community. If you're not lawyers, you don't realize this. Healthcare proxies. You know, when we're young, we think, oh, I don't need a healthcare proxy. Those are for people who are older. You know, you have to be elderly to have a healthcare proxy. Not so. Don't be lulled into that belief, because people who are young sometimes end up incapacitated and in need of medical care, and they're sometimes unable to voice their own preferences for medical treatment. So you could have a situation where you have a same-sex couple. One of them has an accident, maybe a car accident, a skiing accident, or develops cancer or some other illness that renders them unable to make healthcare decisions for themselves. Well, the hospital might not recognize the partner as being a significant person, a significant life partner. Might not even recognize the spouse if the couple have the accident in a different state, a state that denies the marriage. Then they might not even be recognized as a spouse, and they might not be allowed into the hospital room or into ICU. They would be denied access, denied information, and denied visitation. And so healthcare proxies are so critically important, because at that great time of need, who do you want to hold your hand in the hospital? It's your partner. It's your spouse. You don't want to be there alone. So these documents are not for the elderly. These documents are for everyone.
Well, I'm Tim Lynch. I'm your host today on MLGBA Legal Lines. Our guest is Lisa Cukier. If you'd like to call in and ask Lisa a question, please do. Our number here is 617-708-3290. Again, 617-708-3290. If you have caller ID block, you need to dial *82 first. Lisa, I can't believe how important these documents are. I mean, I think in the news recently, Rhode Island even was having difficulty awarding same-sex spouses the right to go in and make healthcare decisions and make funeral arrangements.
Yes.
I mean, the governor vetoed that. So, and that's Rhode Island, right next door.
Right.
So,
right.
I mean,
It's tricky in Massachusetts, too, for funeral arrangements. In Massachusetts, we have statutes and regulations that state that in the event that a person dies, next of kin are able to make funeral and burial decisions for the decedent, and next of kin is considered first the spouse. So if you're in a same-sex relationship that's a non-marital relationship, you're cohabiting and not married, the partner's out. No decision-making rights there as to funeral and burial. After spouse comes children, and then there's a whole step of people who are considered next of kin, but the partner is completely left out. So the partner would have no decision-making rights. There was a case that was decided back in the 80s where a relatively young man had passed away, and his partner knew that he wanted to be buried at a certain cemetery, and he went ahead and consented to his burial. The mother was displeased with this. The mother of the decedent was displeased, and her rights actually did trump. And she went so far as to get a court order requiring that the decedent's body be exhumed from the grave and reburied in the cemetery of her choice. So these are the types of issues that come up. This is why it's important to have documents such as designations of remains. There is such a document where people can actually designate during their lives who they want to have making decisions for them, or what those decisions should be. Whether they want to be buried in a certain cemetery, use a certain funeral home, cremation, what they want their marker to look like. These are decisions that should be considered if there's any chance that there'll be a dispute down the line, because at this awful time in people's lives during a death, that's exactly when you don't want to have a dispute.
Oh gosh, no. You know, it's sad when you see that too, when you see a dispute come up, and that's of course the least thing that the decedent wants. You know.
Right.
So obviously, two very important documents.
Yes,
Now,
yes.
what other types of estate planning things would you recommend?
Well, there's a estate planning tool that I use with some of my clients. So if I have clients who come to see me because they anticipate a dispute on their death relating to their finances, then in their will, a will, just so that everybody knows, is a document that specifies how we want our assets to pass, who we want to inherit our assets after our death. So if we are concerned that somebody might dispute our will for one reason or another after we die, then I can insert some language into a will that's called an in terrorem clause. That's a Latin term. And it's a clause, it's a forfeiture clause that's put into a will that says that if anybody contests my will, they're out. They get nothing. Now, the only way to make this provision powerful is to offer something in exchange. So let's say, for example, that I wanted to exclude you from my will. What I would do is I would say, I give Tim $100, but if you contest my will, you get nothing. So suddenly you have motivation to not contest the will, because you know you're going to get something if you don't contest it, whereas you're going to get nothing if you do contest it. So to make an in terrorem clause work, I would speak to my clients about, how much money is going to do the trick. Maybe $100, it may be $1,000, it may be $1 million. We don't know until I speak to my client. But you want to give just enough to make a disincentive for a contestant to object to the will.
Wow, I've never heard of that. And I've been around estate planning people. That's very interesting.
It's a powerful tool. We pull all
Yes.
kinds of tools out of our back pockets when we anticipate the potential for litigation.
Wow.